I mean, got to see o jogo, so.
I don't follow the game.
But you've seen Mr. Hernandez in NFL football games before.
Mas eu vou tinha olhado o Sr. Hernandez no futebol da NFL.
Yeah, but I'm gonna pay attention to it like that. So.
But I never paid attention to it.
The answer is yes. You've seen him in an NFL football game
Então a
before the
resposta,
shooting.
a resposta foi que eu vou olhar no jogo de futebol da NFL, Sr. Hernandez.
Like I said, I didn't pay attention on the game like that, so. Got to prestar atenção no jogo, so nunca pude falar assim, eu já ver no jogo.
I didn't pay much attention to the game, so I cannot tell you if I recognize or pay attention to him or not.
And you didn't see him in the Cure nightclub that evening.
E vou olhar naquele clube naquele noite.
I pay attention to him.
I didn't pay attention to him, I don't know him.
Or at any point that evening.
Ou a qualquer altura naquele noite.
Talvez model, man, like I said, like I didn't pay attention on him.
Maybe I saw him, but I didn't pay attention to him.
No further questions.
All right, thank you, sir. You may step down. What next step, please?
Your Honor, the counsel just seek to introduce as the last exhibit the binder labeled as Aquilino Freire.
All right, that'll be received as the next number. Exhibit, is it 4 or 5?
4, yeah.
Exhibit 4. And counsel, with regard to what has been received now as exhibits, I think is it 3 and 4, the two binders?
2 and 4.
2 and 4. Insofar as those binders contain grand jury transcripts, they will be impounded. They are not public documents for purposes of any media inspection. All right. Mr. Baez, any further evidence you intend to offer on the motion that is before me?
No, sir. Not at this time.
Commonwealth, do you seek to present any evidence in the motion now before me?
No, Your Honor.
All right, that will close the evidence. Mr. Sullivan, I heard your argument, at least in part, earlier. Is there anything further you want to say with regard to the testimony as I've heard it in the exhibits?
Yes, briefly, Your Honor. So first I'd like to point out 2 areas of Massachusetts law and then go from there again briefly. So first, one doctrine articulated in Commonwealth v. Walker, 460 Mass. 590, 211, an in-court identification arising from, quote, especially suggestive circumstances should not be admitted in evidence even where police were not responsible for the suggestive confrontation or information. So whether a witness was exposed to suggestive information from law enforcement, non-law enforcement, television, media, friends, so forth, under Walker, that is the same. Second, the standard here for Your Honor to decide all trades on unreliability, whether at least portions of the proposed testimony is so unreliable as to require exclusion as a matter of fairness on constitutional due process grounds. And this is articulated in Commonwealth against Jones, 423 Massachusetts 1996. We submit that a combination of the testimony that Your Honor just heard, as well as the papers, the defense has clearly met its burden with respect to the constitutional violation. We also state that if the constitutional violation is shown, then the evidentiary problem is also demonstrated. So very briefly, Your Honor, with respect to the testimony you heard with Mr. Sanchez, I will highlight just a few of the statements that are relevant. Everything was quick, he said. Did not see the car before he heard any voices. They were at the bridge. It was dark. He was in a panic, screaming, crying, crazy. But one piece of testimony that I'd like to focus Your Honor.
All right, now let's assume that's as far as it went.
Yes.
Let's assume we're dealing with the descriptions given in the immediate aftermath of the crime or in initial grand jury testimony. Is it your argument that due process provisions would apply to the court making a preliminary reliability determination on that descriptive testimony?
Not the descriptive testimony immediately after the event. As I understand the testimony and the documents, there was an intervening event, news, TMZ, Facebook, before the first grand jury.
To the extent your motion has legs, that's what gives it the legs.
Yes.
It's some exposure to extraneous information that had an actual effect on the witness themselves, such that they began to provide additional details not earlier disclosed.
Absolutely. That is the thrust, the gravamen of my argument.
Yeah.
So, but I would distinguish those two. The initial statements. There was an initial statement to police, at least with Mr. Sanchez, before the grand jury, and the grand jury we submit is infected. So, with Mr. Sanchez, Your Honor, by way of example, there was initial statements that were made. The shooter was white.
Yeah, let's assume that I have a record and pretty good notes of what the testimony's been.
Very well, but also on the paper as well, because everything was not elicited orally. After, again, we have Facebook, TMZ talking back and forth with witnesses. His girlfriend referring him to news stories. It went from shooter was white to he looked Spanish. Shooter looked American to he looked Spanish. The shooter was driving a brown two-color car to the shooter was driving a silver SUV. Shooter was wearing a white hat with different designs to he was wearing a baseball cap with a logo. The tattoo as well was missing. Anything about tattoos in the earlier statement, presumably unimpacted by TMZ, etc. Both witnesses testified that they saw this TMZ photo, one via Facebook, one presumably TMZ over the internet. Mr. Sanchez initially said he does not know anything about guns. Then later, after exposure to extraneous information, the gun was big, the gun was black, it was an automatic gun. These are the sorts of details that he added. There's another important detail I draw the court's attention to. Mr. Sanchez kept saying that, well, after I saw the news, my memory was refreshed as to what happened. I don't know any human being in captivity, save lawyers, who use that expression. Memory was refreshed. We submit that as further evidence that in the various interactions with the Commonwealth, not just with others, that his memory was indeed refreshed. Not in a nefarious way, but he was exposed to material, as he testified on the stand, that he was shown by police a news report that somehow refreshed his memory from a white vehicle to a silver vehicle. These are all constitutional violations because of the suggestivity of it and the resultant unreliability of it. Briefly, if I may, Your Honor, with respect to the second witness, Mr. Frieri, we have a similar pattern, at least in the written record. Here today, Mr. Frieri could not remember much, but initial statement, he could not remember what the shooter looked like. He could not describe the shooter. He had no other information about the person who committed the crime. After exposure, that changed to, looks like someone who works out with a pretty strong hand, quote, muscular, real manly in appearance. He could not remember what the shooter looked like initially. That transmuted to the perpetrator was an Hispanic white male, not remembering to extraordinary specificity with respect to ethnicity. A couple other things. He could not describe the shooter, initial statement. Then he had plain black baseball hat and the brim, which was about the size of his eyebrows. A lot of specificity. Just a few examples there. One of the most startling things that came out on the testimony, Your Honor, was Mr. Sanchez said, in response to a question, that it looks just like him. That's the very sort of thing that the Perez court seeks or sought to prevent. That is archetypally the functional equivalent of an in-court identification.
Well, yeah.
That is no different from him pointing the finger.
Be questions, careful of the questions they put to the witness.
Well, this is why,
If you invite that sort of response, you're going to get it. And indeed, isn't that exactly what happened in the Perez case? That it was not intended to be elicited, but some open-ended question was asked, and the witness made the in-court identification that no one expected to have been made. And so we have to be, you have to be careful at trial as to asking the sort of questions that could elicit the statement.
We can cross-examine our own witnesses. So in Perez's case, it was their own witness. They're supposed to ask open-ended questions. But and as Perez said, had Creighton Collins come down, the result would have been different, because this indeed was a functional equivalent of an in-court identification. That is why these two binders, Your Honor, are wholly insufficient in terms of providing providing Your Honor with enough notice as to what precisely the government is going to elicit. If they say we are only going to elicit these materials or the statements that were not that did not temporally follow or that came temporally before exposure to TMZ, Facebook, the news, etc., that's fine. However, if we go to these latter, much more specific and muscular statements that clearly, to our thinking, was impacted by the news. Indeed, the witnesses said it. Oh, I saw the news and then remembered. That is precisely what this doctrine of unreliability and suggestibility seeks to prevent. So, at root, Your Honor, the constitutional violation is in the unreliability of testimony that does not come from the witness's memory and the witness's memory alone.
Of course,
it was infected.
The witness is telling us it's my memory. As the last witness just said, I saw the news and it triggered my memory. An interesting turn of phrase, but that's the witness's perception. I suppose I have to determine whether that's credible or whether the exposure to media is such that it has likely altered memory or implanted memories such that we are dealing with reliability as it touches on due process. So I think I understand your argument.
A formalistic statement by the witness that it is my memory in and of itself is not enough.
I got it. Okay.
Very well, Your Honor. But court's indulgence, Your Honor. Very briefly. Thank you, Your Honor.
Okay. Kamala?
Your Honor, just briefly, I think the last recitation is the precise issue before this court, is whether these witnesses at trial can testify as to their present memory of the shooter. And I think it's unprecedented to exclude something like that. I would like some opportunity to look into the case law. I certainly don't think there's anything in Massachusetts, but to give it a second look and make sure what is out there and what are the parameters of excluding a present memory perhaps before at any date that we have next week.
All right.
And again, I think counsel has hit the nail on the head that all of this is fodder for cross-examination. I think it's classic cross-examination for what a witness said on one day and what a witness said on another day and what intervening act occurred in the middle, and the jury can hear all of that and evaluate all of that.
All right, counsel, we're running out of court time here today. We have not reached the motion to suppress the cell phone. But Mr. Baez, you indicate you will have a single witness on that motion, that being Mr. Murphy. And Mr. Murphy could not be here today, but will make himself available next week. I think he is available the 27th and 28th. Have you all discussed those dates? It's one or the other. Have you talked about which is the better date for you?
We've not, the 27th is just
Mr. Baez?
We'd be more than happy to accommodate Mr. Hagan.
All right, then 27, December 27, next Tuesday, we will hear the evidence on the motion to suppress. When last before me...
Just for housekeeping purposes, I may be able to attend that hearing, but if not, in my stead, Professor Sullivan will be addressing that issue, if that's all right with the court.
That's fine, but it will go.
Yes, sir.
And that's perfectly fine, Mr. Baez. When last before me, the defendant had filed a motion for discovery of expert testimony, physical evidence, medical evidence, scientific and forensic tests. And you all asked that I not rule on that at the time because you were discussing that and thought you may be able to work that out.
Correct.
Has it been worked out to the party's satisfaction?
We're still working on it, and we're making progress. We would just ask that we hold that in abeyance until for a later time, but I think...
The later time will be next Tuesday.
Very well, sir.
So have whatever discussions you all needed to see if you can come to agreement. But I don't want to keep it open and find that at the last minute, Mr. Baez, there is evidence or discovery you should have had, but for the court not ruling. So I want to get the ruling in place. We'll deal with that Tuesday then. The defendant had filed a motion to order the Commonwealth to submit some checks for criminal histories with the FBI. I issued a ruling allowing it, denying it as to the scope sought, but it was my understanding that III checks would be made. It was also my understanding, Commonwealth, that you were willing to facilitate the production of quarry records by running them through your system. Is that correct?
We did, Your Honor. We ran them through the state board of probation.
Yeah. Has it been done?
It has been done, provided.
Has it been turned over?
It has.
When?
Today.
Now, Mr. Baez, this brings us, I think, to the most pressing of the motions that you filed today, which is a motion to continue the trial date to September of 2017. Before I deny the motion, you want to be heard.
Yes, sir. I can begin with the very first day I stood in this very position in front of this court, where I did not want to make any representations that I could not comply with. And when I say I could not comply with, I'm referring to rendering effective assistance of counsel on Mr. Hernandez's behalf. We have been working as quickly as we possibly can to handle all of the issues that have been coming up. And taking the case into perspective, I look at this case as really two different murder cases, because you're talking about handling two different incidents in two completely different jurisdictions, both with a firearm, one causing 2 deaths, the other one not, but still, for all intents and purposes, they're 2 different murder cases. I've never had just 5 or 6 months to prepare for 1 murder case, much less 2, tack on the fact that it's an extremely high-profile case, which tends to generate much more discovery than your average case. Whenever you have these types of cases, law enforcement takes that extra step, travels, like, for example, all the way to California, to New York, to Florida. You don't see that in your typical shooting case where one thing happens. We've got cases, we've got incidents and shootings, I think 4 different locations. We are constantly coming across new issues that are coming up that we literally have the professional responsibility to pursue. And I can recall, as we're sitting here, going through, even when we're at the sidebar, when we were discussing a certain matter, I recall a piece of evidence that I have yet to file a motion on. We filed a slew of motions, and several of them are without memoranda, simply because we haven't had the time to do it. Essentially, we're trying this case as best we can, but we're borderlining that area where we're kind of skirting our professional responsibilities here, especially where I'm filing something before the court and saying a memorandum is to follow, when I haven't even done that yet. I feel like that, in conjunction with the many of the things that the current motions still require, really are putting us in a position where if I shut down my law practice today and work solely on this case, I still couldn't get it all done. And that, of course, would cause an extreme hardship, not only on myself, on my employees that work for me, other lawyers, and everyone else involved in this case. We're all working extremely hard. It is really just been several months. And I recall the court taking the position that a lot of the work had already been done before us. Well, I don't see it that way. We've already, in the short period of time that we've taken this case, filed more motions than the predecessor counsel has. And we're uncovering issue after issue that's come up that we simply have not had the time to address. And the fact that I have extra help, and I cannot understate how helpful these other lawyers have been on my team, but I still have to learn it all. I can't get up and say, okay, Professor Sullivan, you handle this part of the case, and I don't need to know anything about that, because that clearly would be malpractice in that regard. I have to know from page 1 to page 35,000 of what's involved in this case. I will go so far as to say this last discovery that was given at the last court hearing, I haven't even looked at yet. I was today's Monday, Friday night, I was in Judge Pope's courtroom trying a first-degree murder case. Here I am, I am working 7 days a week, trying to handle my prior commitments and the commitment for this, and I've never been in the situation where I've taken on more than what I can do. I think what is reasonable in a case like this is to be given at least enough time to have reviewed all the discovery, especially since it's ongoing, we're still getting things. This discovery that we got recently, when I was unable to attend, is over 500 pages, which now includes more witnesses. And we haven't even had the opportunity to send our investigator out to start speaking to some of these witnesses, because we're so far behind the 8 ball on so many of the other issues that we're trying to address that we literally can't get to the next step. And I understand the court's concerns. This is a case that's a little old. And however, the state chose to try this case, or because of the way the investigation unfolded, no real suspect was
was looked into until a year after the case. And law enforcement has had plenty of time to investigate this case, and it still is ongoing. Well, doesn't a citizen accused have at least a portion of that right? And that's kind of where we're at. I mean, I would like to be able to investigate everything in this case, not just as much as I can do in such a short period of time. And again, we're talking about 2 different incidents and 2 different shootings. And addressing several others, but that I've mentioned already. And as we're going through this stuff, we wanted to make sure we met the deadline. December 20th was all evidentiary deadlines. I think we've done that. But I don't think that a representation from lead counsel to Your Honor that I think I've been able to get all the motions in on time is good enough. And I want to be able to tell you, everyone here has done a thorough job, and we are representing Mr. Hernandez to the best of our ability, or at least at a competent level. And there's doing it and doing it right. And doing it right so we're not back here even farther away from the incident where evidence is less reliable, memories have gotten even worse, and justice delayed is justice denied. Now, given all of the, I am certain before the court denies my motion that you can look at the work we've put in and say we haven't been sitting around sitting on our hands. That we've actually been.
It's a complicated case in some ways, but it's a simple case in some other ways.
It is, but when the state is throwing in as much as they can over a certain period of time and putting resources, massive resources into a case, you can't sit back as a citizen and say, okay, well, the state is throwing all this money at an investigation, all this time and all this energy, and, you know, we're going to do our best. No, you have to try and address every single thing, and not just sit back and get overwhelmed by the massive amount of information, investigation, and the resources that were thrown at you. So I think, you know, we're certainly doing our best. We're going to certainly continue, but there is really absolutely no way that we can do everything that we need to do and still render effective assistance to Mr. Hernandez. 5 months or 6 months on a case, it's just not enough on such a complicated case that involves multiple shootings. And I've done plenty of cases. I've handled many murder cases, and these high-profile ones are bigger ones. And before I take one on, I have to make sure that I'm absolutely certain that I can give it the attention it needs. I did so, but I did so anticipating that it would be given a fair amount of time to be able to go through
Well, let's look at the time issue here, Mr. Myers.
Sure.
Because the defendant is entitled to effective assistance of counsel. That's a constitutional guarantee. And I'm comfortable that the defendant will receive effective assistance of counsel. The indictment in this case was returned in May of 2014. The arraignment on May 28, 2014. That is more than 2.5 years ago. Under Massachusetts statutes and under our rules of criminal procedure, in Rule 36 in particular, there is a statutory or a rule-based right to speedy trial within 12 months of arraignment. As well, the Superior Court has a standing order 286 or 2-86 that establishes a homicide or a murder trial as a C-track case presumptively to be tried within 12 months of arraignment. At the time Mr. Hernandez was arraigned, he was already involved in criminal proceedings in Bristol County and had counsel already in place. He had Mr. Rankin and Mr. Stoughton, who then appeared here in Suffolk County and entered an appearance. The parties came before me early in the life of this case and indicated that at least as to Mr. Rankin and Sultan, their principal focus had to be on the Bristol County case that had a trial date set, and they were obligated to focus on the evidence in that case, which they did. I essentially gave the defense a stay of any pleading practice during the Bristol County case. Notwithstanding that, pursuant to Rule 14 of the Rules of Criminal Procedure, the Commonwealth was providing Rule 14 discovery, even though Mr. Rankin and Sultan were focused on Bristol. The Bristol case ended a long time ago. The attention then turned to this case for well over a year's period of time, until in June of this year, there was a motion for pro hoc vice admission of you and other counsel, the representation being that you were prepared to enter an appearance and to represent Mr. Hernandez. That led to a hearing that was before me on July 21. On July 21, Mr. Rankin and Sultan were allowed to withdraw based on your filing an appearance and entering that appearance in open court. I think I was told at that time that discovery was being transferred and that you would be in a position to handle the case going forward. Now please understand, when successor counsel comes in, no matter how good or how bad, how skilled or not, the case does not go back to the starting gate. It's already on its track life, which in this case, it had already exceeded its track life. I set the trial date in this case, I think at a hearing we had in August. I think it was August 16, in this courthouse. You were present, as was the Commonwealth. We talked about the trial date. You would ask for a spring date. I had indicated I'd like to try it in the fall, meaning this month or last month. Essentially, we split the difference, not by your acquiescence, but by my ruling, and we set it for February. From that date, that gives you a full 6 months to become familiar with discovery, much of which had already been marshaled, and some motion practice already underway. And I note, and I must say, that it is the first in my somewhat limited but 15-plus year career where I have a defense team of the magnitude that is now assembled in this case. On the motion to continue, it is filed on behalf of yourself, of Mr. Sullivan, of Ms. Baden, of Mr. Proctor, of Mr. Leontier, and of Mr. Spiro. That is 6 fairly qualified and skilled attorneys, all involved in the representation of Mr. Hernandez. I'm confident that with that much legal talent and under your supervision, that this case can be prepared and ready to try in February. Now let me tell you as well, the court's already started making arrangements for that impanelment, because as I've alerted you all before in hearings, there's a good deal of work involved in scheduling a case of this prominence, at least media interest, to try. We have had meetings with our state jury commissioner to increase the size of the jury pool. We have alerted all other trial sessions in Suffolk County that at least for a 3-day period in February, they will not be able to access the jury pool. That is, the jurors are going to be brought in solely for this case. It's my understanding the jury commissioner either has or is about to send out notices increasing the jury draw for the days of February 13, 14, and 15. The court is also making arrangements regarding facilities, media facilities, regarding an overflow court space so that if the public audience exceeds the capacity that can be held in a courtroom, we would have space available. And court security is making arrangements for transferring or reassigning officers. We have made arrangements for jurors and accommodating the jurors during the course of trial so that they may safely and comfortably enter the courthouse without exposure to the public brouhaha and be escorted in and out on a daily basis. It's all a way of saying there's a lot involved in the case that is already underway. Arrangements have been made, and the motion to continue simply is, I don't view it as necessary. I also view it as untimely, and I am satisfied that you will be able to provide effective assistance counsel to Mr. Hernandez on a trial starting February 13, and therefore I must deny the motion. As to the other motions you filed today, I don't want to take them up this afternoon. If there are some that are in fact timely, that ought to be addressed relatively soon, I will hear you on those on Tuesday. I'd also expect the defense intends to have Mr. Murphy available on Tuesday. Is that correct?
Correct.
All right. So we will see Mr. Murphy on that day, and I'll receive his testimony. On the motion either to suppress or in limine regarding identification, I will take that under advisement. As to the motion regarding ballistics evidence, so-called, or comparative firearms analysis evidence, I would expect to have a written decision on that in the next day or so. We'll have that out before the end of this week. Is there anything else we should address now?
I would like to raise one issue.
Yes, sir.
It's simply a time issue. We still have no firm list of the Commonwealth's witnesses. The list is currently, taken, what's the current list you have on it? 150 witnesses?
Now, what do I see represented in the motion to continue? 26 firm witnesses and 54 as maybe?
Well, that was the last count. I believe there's additional names. Now, Mr. Hayden can address that. That was the last count that we had as the last conversation.
Excuse me, that's just civilian witnesses.
Civilian.
That doesn't include law enforcement, which list is much larger.
We cannot evaluate these witnesses unless we know who the witnesses are. Maybes, 55 maybes, it's not others.
You all talk about it. You talk about it. I mean, a practice that I often see is the Commonwealth will list every witness who appears in any police report just in case someone happened to be the first one to see something on the ground, or the one to safeguard it, or the one to transport it, and unable to anticipate what sort of custody or chain of custody issues may be live, what sort of authentication issues may be raised. Lists tend to be over-inclusive. And again, in my experience, it is counsel communicating with one another, defining what will be the live or genuine issues that help to tailor down that critical list. And I invite you to do so. And if I can be helpful with that, I'm not going to do it this afternoon, but maybe we could spend some time on that on Tuesday. I'll be happy to put my thumb on Mr. Hagan.
So we're going to argue all of these motions for, call it spoliation, that's a civil term, but we've got two major motions on spoliation, motions to view evidence, motions to produce evidence in this trial. Are those all going to be handled on Tuesday?
Well, we can start handling them. Let me look at what you filed. I mean, you just filed it this morning, so.
Last night at 11:30.
Last night at 11:30? You just missed me.
Just missed the deadline.
I'll look at them and you tell me which you feel are time sensitive and ought to be addressed right away. and we'll try and reach them on Tuesday. Commonwealth, if you can be prepared to address the various motions.
I will submit that to the court, which ones we'd like to address on Tuesday.
And to the Commonwealth, I assume?
I'm sorry?
Can the Commonwealth be advised of what motions are going to be pressed on Tuesday? So we
Yeah, talk to each other, for heaven's sakes. Let me see Mr. Byers and Mr. Hagan at sidebar.